So, welcome back, sir. In the last class, we have completed the breach of contract. We'll revise breach of contract once, then we'll do the scanner. So, first of all, what is the meaning of the breach? What is the meaning of the breach? Breach means failures to perform the respective duties. So, your duty is to listen, but you're not listening. You made the breach. My duty is to teach. I'm not teaching. I made the breach. Your duty is to pay the money. You're not paying the money. You made the breach. My duty is to give the delivery of the car, but I'm not giving the delivery of the car. I made the breach. Breach means fails to perform respective duty or makes it impossible to perform respective duty. I entered into agreement with Aditya to give delivery of this pen for 10,000 rupees on 31st March. But before 31st March only, I am giving the same pen to Ishwar. What I did, I am making it impossible to perform my duty on 31st March. On 31st March, I should give it to whom? Aditya. But before 31st March only, I am giving the same pen to Ishwar. So what I am doing here impliedly, breach. That is making it impossible to perform its respective duties. Breach is of two types: anticipatory breach, actual breach. What is anticipatory breach? Direct question in the exam. So many times it was asked. So what is anticipated breach? Already asked so many times in the exam. Direct question: star, superstar, star, megastar, megastar, superstar. आता बेटा किधर आता? What is anticipatory breach? Breach made before the date of the performance. For example, listen. Look at the screen only. So I entered into a contract with कौन है बेटा ये? Nikhil. SG entered into a contract with Nikhil to deliver the car for 50 lakhs on 31st March. When the contract is entered, 1/1/25. When we have to perform 31st March. So Nikhil is waiting. Srinath sir will give delivery of the car. But on 14th February only, I made a call. Nikhil, I am not going to deliver the car to you on 31st March. This is date of performance. Before the date of performance only, breach is happened. It is said to be anticipation. Anticipation means expectation before happening. What is the date of contract? 1/1/25. What is the date of performance? 31st March. What is the date of breach? 14th February. So anticipatory breach means breach made before the date of the performance. It is of two types: anticipatory breach, express repudiation, implied repudiation. Repudiation means cancellation. So Nikhil, I made a call to Nikhil. I said, Nikhil, I am not going to deliver the car to you on 31st March. When I said 14th February, it is express repudiation. I have to give the car to Nikhil on 31st March. Same car I am giving to Ishwar on 14th February. It is implied repudiation. Words are not spoken, words are not written, but it is understood that I am going to make the breach because I have only one car. That car I should give it to Nikhil. Before that date, I am giving it to Ishwar. Next, remedies available to aggrieved party. Options available to aggrieved party in case of the anticipatory breach. Options available to whom? Aggrieved party. So on the date of breach, 14th February, Nikhil can resign the contract. He can claim damages. Damages is equal to market price on the date of breach minus contract price. I entered into agreement with Nikhil to delivery of this car for 50 lakhs. But on the date of breach on 14th February, the car in the market price of the car is 52. But I agreed to give it for the 50. Market price on the date of breach minus contract price. Because of my breach, how much is getting lost? 2 lakhs. He can claim 2 lakhs. One more option available to aggrieved party. But what is the date of contract? 1/1/25. Date of performance 31st March. Today is 14th February. He can treat contract as operative till the 31st March. He can wait. So aggrieved party may treat contract as operative and wait till the date of performance, that is 31st March. On 31st March, if I am giving the car, who I am? Defaulting party. If defaulting party agrees to perform, aggrieved party has to accept it. If I am giving the car, you have to accept the car. On 31st March also, I am continues to make the default. Defaulting party continues to make the default. aggrieved party can resign the contract on 31st March. He can claim the damages. Damages is equal to market price on the date of performance minus contract price. On 31st March, the same car in the market will be 54 lakhs. But I agreed to give it for 50. Because of my breach, how much loss you are getting? 4 lakhs. You can claim that 4 lakhs. This note came in the exam beta. वो एग्जाम में पूछा वो नोट बेटा this is date of contract, date of performance, date of breach. In this period, you are not rescinding the contract, not cancelling, treating it as operator. You are waiting till the date of performance. But here, unfortunately, car is destroyed by fire accident. Car jal gaya. Then contract will become void contract. You cannot claim the damages also. ये question exam में पूछा. So, if the goods are destroyed after date of breach and before date of performance, aggrieved party cannot claim the contract, cannot claim the damages because contract will become void. Vaishnavi, where you are psychologically? Not here for sure. Oh? You're somewhere. Physically here. Thinking about mummy, daddy, biryani. Hey. Actual breach of contract. Next concept is the actual. On 1/1/25, I said to Nikhil, on 31st March, I will give 100 bags of the rice in 2 lorries. Red lorry, black lorry. This is date of contract. This is date of performance. On 31st March, I made a call to Nikhil. Nikhil said, good morning. I said, bad morning. He said, why? Because today I am not going to deliver the rice. Date of performance is equal to date of breach. Breach made before date of performance is anticipatory breach. Breach made on the date of performance is actual breach. It is 2 types. Actual breach on the date of performance for whole obligation. Actual breach on the date of performance during the course of performance. Whole obligation means I am not going to deliver the red lorry 50 bags or black lorry 50 bags. I am not going to deliver anything. Whole obligation. Which obligation? Whole obligation. So 50 bags are delivered by red lorry, but remaining 50 are not delivered by black lorry. इसको बोलते हैं during the course of performance. Breach made during the course. आधा हो गया, आधा नहीं हो रहा बेटा. आधा हो रहा. FX. I have to deliver this rice bags on 31st March. But I am supplying on the 4th April. I made a breach on 31st March. Subsequently, I am supplying. Performance beyond the specified time. Performance beyond the specified time. I am supplying in the April. If is accepting, cannot claim damages. Not accepting, can claim the damages. This is all about the breach, actual breach and anticipatory breach of contract. Breach, anticipatory breach and actual breach. Any doubts still here? Brothers, sisters, full clarity. Shashi Babu. Ara beta. Next. With this chart, we can complete this chapter. Next. Remedies for breach of contract. Remedy means course of action or solution. Remedy means course of action or the solution available to aggrieved party who incurred the loss. I have to give the car to John, but I am not giving the car to John. He gave the money, but I am not giving the car. What John can do me? Rights of aggrieved party. He can sue for rescission. So John said, I don't want your car. He can cancel the contract. He can cancel the contract. And sue for damages 15 stars. How many stars beta? देखेंगे बेटा बाद में. Next, sue for specific performance. Sue for, which means demanding the performance as it is specified in the agreement. So in the agreement I said, if you give me 1 lakh rupees, I will give Gandhiji pen. So you are giving Gandhiji, you are giving me 1 lakh rupees, but I am unable to give Gandhiji pen. Then I said, okay, I made a breach, so I am ready to pay damages. So how much loss you are getting? He said, even you give 1 crore, I don't want, I want Gandhiji pen only. That is said to be sue for specific performance, demanding the performance as it is specified in the agreement. But there are few cases where you cannot claim specific performance. First one is the void agreements and illegal agreements like minor, because since it is void ab initio, you can't claim. Say it is an unenforceable transaction. Next, if the money, we can measure the amount of loss with money. For example, this spectacles is destroyed. है ना बेटा? The same spectacle is available in the market for 10,000 rupees. So amount of loss is measurable. Same brand, same color, same model, same lens available. So you can measure the amount of loss with money. You can't sue for specific performance. I want that spectacles only. How? Broken already. Next, contract is personal in nature. Personal in nature. So Nikhil agreed to give his daughter to Ishwar for the marriage. So Nikhil daughter मर गया. I want the daughter only. How? Impossible. वो मर गया है ना बेटा. Singing, dancing, painting. He lost his voice. He lost his hands. You have to paint means how can? So you can't sue for specific performance in if it is personal in nature. So sue for rescission, sue for specific performance, sue for injunction. Injunction means demanding court stay order. Demanding the court to stay order. I have to give the car to Aditya. Subsequently, I entered into for 1 lakh with Aditya. Subsequently, Ishwar is offering me 1.5 lakh. I said yes. Then Aditya can go to court of law to stop this transaction. To whom I have to give? Aditya for 1 lakh. Subsequently, Ishwar is offering me 1.5 lakh. I said yes. So Aditya can go to court of law for selling the car to Ishwar for 1.5 lakh because I made a promise with Aditya already. So demand in the court to stay order. Next, quantum merit. Quantum merit means pay for as much as benefited. Quantum means quantity. Merit means advantage, benefit. Pay for as much as earned. Pay for as much as benefited. So if I sing 10 songs, you have to give me 10,000 rupees. If I sing 6 songs, you have to pay for the 6,000 rupees for 6 songs. उसको बोलते हैं क्वांटम मेरिट. इसमें से सबसे important topic will be sue for damages. This was decided by a famous case law, Hadley versus Baxanley. ये case law भी you should quote in the exam. So in this case law, we discussed the case law also. So we're taking the mission to some other city for the repair, but there was a delay in the delivery. So the factory owner filed a case. It was held that, but in that case law, the factory owner getting a loss of 10,000 rupees, but he was demanding 15,000 rupees. Then court held that damages are not punishable in nature, it is compensatory in nature. Damage means making good of financial loss. Because of my breach, you are getting a loss of 10,000. You can demand 10,000, but not 15,000. Yes or no? And types of damages, very important from exam point of view. This one, very important. These two are very 10 stars. This is 5 stars. This is 1 2 stars. This one, liquid damage versus penalty. Done. I let a keep no beta. 10 star. Wherever I'm keeping the star now, focus on the star. Otherwise, you have to see stars in the exam hall. First one, ordinary damages which arise in the ordinary course of business due to breach. Which arise in the ordinary course of business due to breach. Which has the direct relationship with the amount of loss. Loss is 50,000. You can claim 50,000 rupees only. So amount of damage is equal to market price minus contract price. I agreed to give something to you for 10 lakhs. I am not giving. You're taking outside the same thing for 11 lakhs. How can you much you can claim? 1 lakh. We can know this kind of damages after breach. After making the breach, we know. Next, special damages ये भी लिखना है एग्जाम में. ये दोनों लिखना है बेटा. साथ. These are the damages which are known to parties at the time of entering into contract. So you have to pay the ICA exam fees before 10th January. You can pay up to 15th also, but you have to pay 1,000 rupees extra. Who said? ICA. When? Before only. When you're entering into contract only, they said. Then, so which are known to parties at the time of entering into contract itself. So we know the amount of damage before breach. Here we know the amount of the loss after breach, because at the time of writing the agreement, we will write if you make the breach on performance, you should pay this much extra. Next, this should be even we know the amount of damages before prior on also. They should be reasonable. It should be compensatory in nature but not punishable. Punitive, vindictive, exemplary damages. These are punishable in nature. Since damage is supposed to be compensatory, but these are punishable in nature. Generally, court will not award this kind of damages. Court will award these damages only in two cases: breach of promise to marry after engagement, you are breaking. We have seen a beautiful example, and wrongful dishonour of a check. Moreover, amount on the check is small, we can claim more damages. Amount on the check is big, larger, we can claim the smaller damages because of the goodwill. Small amount is no, so lot of goodwill will be affected. Next, damages for the inconvenience, discomfort, or the remote damages. We have discussed the case law Hoops versus London SE Railway Company Limited. So that case law also asked in the exam 2-3 times. So what was happened here, which is a very remote consequence with the, you're claiming the damages which is remote consequence with amount of the due to breach. So you cannot claim this kind of damages. So we have seen a case law, the same case law facts will come in the exam. So one guy was booking a railway ticket. Unfortunately, the train was stopped in another station. Then he was supposed to walk in the early morning from one station to another station. Moreover, it was very cold. So because of that, his wife and children was affected. Health is affected. He joined in the hospital. Then so court held that you cannot claim all the hospital expenses. You can claim only the expense from the previous station to this station. That's it, which has direct consequence. Liquidated damage and penalty exam में आता बेटा, difference only आता exam में. So liquid damages is genuine pre-estimate of amount of loss which are proportionate in nature, and penalty is punishable in nature which is disproportionate in nature. Next, nominal damage. So technically I made the breach, but you did not incur any financial loss. There is a technical violation of legal right is that, however, aggrieved party did not incur any financial loss. You are getting benefited, in fact, not getting any loss. As a matter of legal right, you can claim some amount as a damage. That is called as the nominal damage. These damages are nominally in amount: 5 rupees, 10 rupees, 1 rupee, 100 rupees. It is called as nominal damages. Next, stipulation as to interest. I gave the loan to Ishwar on 1/1/25. He supposed to repay on the 1/1/26, 1 year loan. When I give beta 1/1/25. When he is supposed to repay 1/1/26. But when he is repaying 36/26 after 6 months. This is non-defaulting period. This is defaulting period. Here rate of interest is 2%. Here also 2%. It is not punishable in nature. Here 2%. Here 1%. Not punishable in nature. Come ho gaya. Here 2%. Here 3%. Still not punishable. It is reasonable. Here 2%. It is 13%. It is punishable. It is 0%. It is 2%. It is reasonable only, not punishable. Since I made the breach on 1/1/26, you are asking the cumulative higher rate of interest from starting. It is punishable in nature. So he will give any combination. He will ask whether the interest is punishable in nature or not. This interest is punishable in nature or not. So with this we have done with the breach whole chapter. Done. Have a great time. Enjoy the day. Prepare well. SG signing off. Take care. So in the next class we'll do the scanner. Done. So if you do this revision and that scanner, fit for the exam.